We receive lots of reports in which lawyers find themselves trying to prove that certain advice was given, contrary to what a client now says. Those lawyers search desperately for that note to file, or letter, or email, or something that will corroborate what the lawyer says actually happened and prove their version of events. Often the search is in vain, and we're then into protracted litigation with no certainty that the defense is going to prevail. But not always, and it's the not always that I'm going to talk about today. A report in which the lawyer found that little nugget of evidence. It's also simply the best example I know of how a note to file saved the day for a lawyer. And that message remains as fresh and relevant today as it was when it was reported to us 27 years ago when I first started at Lawyers Insurance Fund. Here's what happened. Our lawyer acted for the purchaser, let's call him Mr. Smith, of a house on rural land. Smith assumed that the house included a very normal-looking front yard. The realtor had apparently represented as much. The purchase completed, and Smith and his family moved in. He then discovered, much to his dismay, that the neighbor's property line ran diagonally across his front yard, making his big, rectangular-shaped front yard about half the size and, in fact, triangular-shaped. He sued everyone, the vendor, the realtor, and his lawyer, Mr. Jones. The claim against Jones was that Jones never gave him any advice on boundaries or the value of a survey. Appreciate that 30 years ago, as a purchaser's lawyer, you protected your client from these sorts of issues by recommending that they get a survey done. Jones thought he had dealt with the issue of a survey. So here we have a typical he said situation emerging. Our Supreme Court on more than one occasion has stated, where there is a conflict between the versions of events given by the client and the lawyer, all other things being equal, the client's version is to be preferred. Jones combed through his entire file. What he found saved the day. On his file was a sketchy handwritten note, I can see it clearly right now, upper left-hand corner, and this note said, discussed boundaries with S, does not want to obtain survey, will check pins himself. Voila! We now had a real defense to the claim, and there was no question that this one handwritten note strengthened our hand immeasurably when dealing with the lawsuit. In fact, we would have taken this to trial, but for Mr. Jones's reluctance to use his time this way and be put through the stress of a trial. He pragmatically preferred to pay a very small amount from his deductible to settle the matter, and that's exactly what we did. Without that note, however, he and we would have paid a lot more, or run the risk of an uncertain result at a trial in which not the lawyer's, but the client's version of what happened would likely have been accepted.